As many of you know, I'm Judge Bill Dressel. I have the privilege of being the president of the National Judicial College. And it's also my privilege to be here and preside over the 126th Robert H. Jackson Lecture. The title this year is Reflections of an Executive, Legislative, and Judicial Career.
Thank you, Your Honor. It's truly a privilege and honor to be here. I'm hopeful that the introduction isn't longer than my speech. This group has heard from university professors, business professionals, judges, federal officials, and even presidents. And therefore, in preparing for this lecture, I felt it incumbent upon me to present something no other speaker might be able to bring before you. As a new governor in a state with economic challenges, probably like many of the states where you come from, I tend to be asked most often about the budget. I'm also asked about our education system and some of the changes that I'm seeking to make in those regards. And so I fully realize that those things have nothing to do with why you are here today, and it will be a bit refreshing for me to talk about something else. So I am going to talk about something a little more personal, which has the added benefit of simultaneously being somewhat broader in context. That is my own experience in all three branches of government. And as you've just heard from my background, I have had the privilege of serving in the Nevada legislature, on the Tahoe Regional Planning Agency, as chairman of our Gaming Commission, as the Attorney General, as well as a federal judge. Now nationally, this is somewhat rare, and at home here in Nevada, it was a first. No governor before me has had experience in all three branches of government. And I can also tell you that there are not a lot of federal judges out there who've given up a lifetime appointment to do what I've done. And I'm going to share a story with you because it has the added benefit of being true. The judge talked about the difficulty in the decision-making process that I had to go through when I made that decision to run for governor. And so certainly I had to keep a very small circle of friends and family that I talked to, primary of which was my father. And my father said, "Son, you have a lifetime appointment. You have a job that you love as a judge. You have the ability to control your calendar and your schedule. You have a great salary, and you have a guaranteed retirement. What are you thinking?" So, the other person obviously that I went to speak with was my wonderful wife, Kathleen. And we made this decision, and we decided that it would be very important to get out of town and go to a very remote place and be able to let off a little steam and decompress. And we were gone for a week, and we were up in the Sierra Nevada mountains. No telephone, no television, no cell phones, none of those things. And we came back after a week, and we came home, and message machine, or the telephone was full of messages. And I checked the messages, and one of them was my father. And he said, "Son, I heard you made your decision. I guess you know what you're doing." So I called him back. And I said, "Dad, that wasn't quite the endorsement I was looking for." And I said, "Dad, I'm running for governor. It's not like I'm running away to join the circus." And he said, "Son, you are." My dad's a very wise man. So in any event, and again, that has the virtue of being true. As judges, you might enjoy the irony of considering my resume with regard to the separation of powers doctrine. Federalist Paper number 47 expressly warned, "The accumulation of all powers, legislative, executive, and judiciary, in the same hands may justly be pronounced the very definition of tyranny. Now, I don't take that personally. Of course, in the Federalist Papers, James Madison was writing about the separation of powers in the context of one person or a small group of people holding all such authority. He frowned upon the simultaneous accumulation of all three forms of governmental power. In my case, my career has spanned approximately 17 years. I consider the experiences that I've had a tremendous asset. The experience of having served in all three branches gives me a perspective most governors, or for that matter judges, don't have. And I'm very thankful for it. Because of my somewhat unique vantage point, I would like to spend a little bit of your time today talking with you about two general ideas. The first is the traditional separate but equal doctrine and how I see the three branches being unique in character and conduct. The second is what some writers have called the so-called friction between the clear separation of powers. That being the idea that each branch often exercises powers exclusively reserved to some other branch. They are not silos, and in some instances, they are not even separate. Let me begin with my view of the character and conduct of the three branches. The three branches of government have distinctly different personalities, if you will. These differences go beyond the actual work of each branch. The classic roles of create the law, administer the law, and interpret the law. In my experience, there's a different temperament in each of these branches. Something we hear about most in the judiciary, but which I can assure you exists in the other branches as well. The legislative branch is truly the closest to the people, especially in a small state like Nevada. And so it acts the most populist in its conduct of business. It can be the most unruly, and I assure you that's what's going on in Carson City. Right now, where decorum sometimes slips when tempers fray. This is the people's branch of government. Nevadans and most people in small states have an expectation of speaking out on legislation. Hearings can last for hours as everyday Nevadans tell their legislators how they feel about a particular issue. And you listen, and you better listen. Truth be told, the reality isn't quite that bad, but the legislative branch does seem to have the most challenges with its public image. Lawmakers are also the most utilitarian players in government. When I served in the legislature on the Judiciary Committee, interestingly enough, it was not uncommon for lawmakers to draft their own amendments. Staff would then rewrite, and as you might expect, our work was very much hands-on. Legislatures tend to operate on two speeds, very slow and deliberate, with lots of testimony and debate, or the exact opposite, frenetic and fast-paced, often with the rules suspended and no time whatsoever to consider what you're voting on. That's what's happening today. Our legislature, as I said, is 120 days. We've had approximately 107 days of legislative session. I've received a little over 100 bills on my desk, and there are still approximately 600 to 700 bills that are still alive that have to be considered along with amendments and then along with a budget in the next 13 days. So I have the full expectation that I'm going to be getting a stack of bills for my own consideration in a very short amount of time. In the legislature, by its nature, there are times when some of the legislators push that red or green light to vote based solely on what their caucus leaders had told them to do. Not the best process. The judicial branch, as you well know, or are coming to know, if you are a new judge, operates very much at a different pace. Judges have more time for deliberation than either of the other branches, and the job can be isolating. When I was on the bench, I found it comforting to be the one in charge of my calendar of courtroom conduct in the manner in which information came before me. One simply does not have that much control in the other branches of government. Now I'm going to tell you another little story with regard to control. I had the privilege of sitting on the Ninth Circuit Court of Appeals a half dozen times. And I also had the opportunity to be sitting with a very intellectually gifted judge. I'm not mentioning names today, but I do mean that. Now on this particular panel that I was sitting on, it was in Pasadena, California, and we would typically listen to 6 cases during the course of the day. This judge was the presiding judge who had the authority or the discretion to determine the amount of times that those oral arguments would occur, and they were set for 20 minutes per side. The presiding judge asked the other 2 judges, myself included, if we would mind if we'd limit one particular case to 10 minutes each side, because the issue seemed pretty clear. So we arrived in Pasadena, we're listening to the arguments. The case that preceded the case where the oral arguments had been limited was ongoing. There was a particularly unruly attorney who was making the argument, was interrupting the presiding judge, which is probably not the best strategy when you're making a case or arguing your case before the Ninth Circuit. And suddenly the presiding judge looked at him and said, "Thank you." And the attorney continued to argue, and the presiding judge said, "Do you understand what thank you means?" And the attorney said no, and said, "Thank you means you're done." Attorney dutifully sat down. Next argument, or the next case, is announced. The attorney whose case had been, or his oral argument had been limited, launches into his argument, starts to complain that his argument had been limited. There's no possible way that he could limit his argument to 20 minutes, and 10 minutes was certainly not enough. And he said, "Your Honor, brevity is not one of my strong points." And the presiding judge looked at him and said, "Neither is clarity." Thank you. And the attorney continued to argue, and the judge said, "Didn't you hear what I said?" And I said, "Thank you." "Weren't you in the room in the last case?" "Yes, I was." "Did you hear what thank you meant?" "Yes, I did." And turned around and sat down. That's what I call control. But, as you all know, judges are sometimes susceptible to what critics call black robe disease, because it's hard to question a judge. The process of appeal is steeped in the rule of law and tradition. There's simply nothing like it in the legislative or executive world. So someone told me when I took the bench that one of the differences between being a judge and elected official was, first, as a judge, you make a decision and your phone does not ring, which is a nice change. And the other is your Christmas card list goes from being about 1,000 to 10 in a very short amount of time. He was right, I assure you. Even elected judges, like we have here in Nevada, remain above the fray, except in the most extreme instances. Time is on the judge's side. Public opinion, protests, editorials, and even the testimony you hear do not run at the same speed or fervor as in the other 2 branches. William Howard Taft, the only United States president to go on to serve as a Supreme Court justice, had this to say: "Presidents come and go, but the Supreme Court goes on forever."